So tonight we're going to talk about Trust 101, why you need a trustee, or do you need a trustee? Do you need a trust, and how they work? Previously, I talked a little bit about the importance of collaboration and working with quality partners, and some of the challenges that people have in selecting a trustee and selecting the right people to steward their capital and their resources. And oftentimes it's difficult to find the right person. So tonight I'm pleased to be joined by Shelly Donaldson. Shelly serves as Vice President and Business Development Officer at Cumberland Trust Company. She's got a long, extensive bio that I read previously, so I'm going to just make it really short. Shelly, she has a lot of experience in estate planning, over 20 years in estate and trust planning. She's highly credentialed, and since we're late getting started, Shelly, I'm going to make it really abbreviated, and I'm going to pass the baton back to you. And Shelly's going to give us a primer on Trust 101. And again, gang, sorry for the confusion and the late start here. So let me try this once more time and pass the baton to Shelly. Okay, Shelly, hopefully you can take the screen and we can try this one more time.
All right, is it now showing my slideshow?
Yes.
All right. Hi, everybody. So I'm Shelly Donaldson. As Jeff was saying, I've been a estate planning and tax attorney here in the Atlanta area for nearly 20 years. I mean, I grew up in the estate planning world. My dad was a career estate planning attorney. So I've been witnessing wills since I was 14, and that was many, many moons ago. All the gray hair shows that I actually have very dark brown hair. It's now very gray now. So I guess that kind of shows my experience. But, you know, I'm here today to really kind of talk through what is a trust, why and when might you need one, and then once you've kind of said, okay, I do need one in this instance, help you find the right trustee. Because, you know, attorneys spend a whole heck of a lot of time concentrating on the really technical tax provisions, and everybody says, oh, I want to make sure I don't pay any tax and I want to do this. Well, the soft stuff is really where plans blow up, and making sure that you think through how you're planning your documents, and you think through who's going to be holding the reins once you're not able to do it yourself. Those are really the things that make or break an estate plan. So just when you spend the 5 minutes sitting at the attorney's office thinking about, oh yeah, I'll just name my brother Bob as the trustee, I challenge you to think a little bit longer and harder about that. And we've got a few slides that'll talk specifically to that. But as we're diving in, there it goes. All right, so this is kind of our roadmap of how we're going to talk through things today. We're going to talk through trust basics, making sure we're all using the same vocabulary. Then we're going to talk through about the different kinds of trust and when it's a good idea to have those types of trust and how they can be used. And then we'll talk about, okay, you've got a trust or you need a trust. How do you choose the right trustee? That's just a roadmap of where we're going. So let's talk about trust basics. What in the world is a trust? What is this word I've been throwing out there? And this is the legal language for it. It's a legal arrangement. It's not an actual entity, even though people think about it as an entity. It's really an agreement between you, the grantor, and the trustee to do what you put into the document to manage your assets for the beneficiaries. Legal mumbo jumbo. So what does that really mean? So simply put, a trust is just a plan. It's the plan that you put into place for all these bullets. If incapacity strikes, if you have a child with a disability, I've sat on boards for many developmentally disabled communities. I have a brother who's developmentally disabled. And it really, all of our families are touched by some level of disability at some point in your family. Autism is just running rampant, and the number of families that disability planning touches, that it's just off the charts. Also, if there's a family business, who's going to take care of that? It's these different things in the bullet points here. It's creating a plan to make sure these things are handled. So who are the three players that we're talking about here? We've got you, the grantor. You're the architect. You're the one that actually defines the purpose. You name the beneficiaries. You say what powers the trustee is going to have, such as are they able to create loans to the beneficiaries? Are they able to loan money to themselves? That's kind of a tricky one. You define the powers, those things, all those language in the back of all the mumbo jumbo language in the back of the documents that your attorneys draft, that really means something. So that's what the grantor is. The trustee, that's the person who picks up the reins and is supposed to look at the document, read the document, and then actually go forth and manage the assets for the benefit of the beneficiaries in the way that you said in the document. The third player is the beneficiary. Who is it actually going to benefit from this trust? So if we're talking about a revocable trust, if you're incapacitated, that beneficiary is probably you. After you're gone, the beneficiaries are typically family members. Could be friends, could be charities, but typically family members. So those are the three key players to keep in mind. All right, talked about the players. Now let's talk about the two main categories of trusts. When people pick up the phone and call me and they said, Shelly, I need to talk to you about being a trustee for my trust. I said, great. What kind of trust are we talking about? And really what we're talking about here is a revocable trust or an irrevocable trust. Revocable trusts are kind of what they sound like. You, the grantor, you're setting this up, but you can change it anytime you want. You can cancel it, you can change it, you can play with it, you can do whatever you want to with it because it's revocable or revocable, same thing, until you become incapacitated or you die. Irrevocable trusts are the opposite. Once you actually put them into place, think of them as being in stone. There's some new provisions here in the Georgia statutes that actually let you make revisions to, well, limited revisions to irrevocable trust. But when you're putting it together, don't plan on that. Plan on making the document flexible enough so that it can flow with the times and you won't need to revise it. So those are the two main categories of trust, revocable and irrevocable. Now let's talk about when would that be a good idea that you would set up either of those trusts. So first, revocable planning. When would I want to set up a revocable trust for me? I'm going to breeze through the first one. I'll come back to it, the planning for incapacity. But going to the next bullet points, the privacy after death. That one, that comes into play if you're talking about celebrities, or if you've got a kind of a funky estate plan that you don't really want the whole world to know about, because if you put it in your will, all of those provisions, you know, your funky estate plan, you put all of those provisions into your will, that has to be filed with the court at the time of your death. It's now public record. Anybody can go see it. I mean, I could go pull up Michael Jackson's will. Can't pull up Prince's because I don't think he had one. But, you know, it's all public record. So that's the privacy. Avoiding probate. So I used to have clients come in and sit down with me and say, I want to avoid probate. And I'd kind of scratch my head and say, okay, but you're a Georgia resident, right? And it's, yes. I was like, okay, well, avoiding probate's really not that big of a deal in the state of Georgia. If you've got property outside of the state, okay, avoiding probate in those jurisdictions, totally get that. Especially if you decide you want to move to your house up in the Highlands or down to the beach in Florida. Those states are totally different. Those states are expensive and an absolute total pain in the rear to go through the probate process with the courts. Here in Georgia, it's really no big deal. Really, they have the executor come into the court, say, raise your right hand, promise to do everything in the will. Great, come back and tell me when you're done. And that really is the whole process for probate. I mean, sure, there's a lot of stuff that has to be done to kind of close down your financial life, but whether you have a revocable trust or you've got a will, that stuff is still kind of the same. Certain assets, this last bullet point, certain assets, transferring those assets after death can be easier if it's already in a revocable trust, because it's all kind of nice and neat with a pretty little bow on it, you know, ready to be transferred around. But it's really not that big of a deal here in Georgia. But let's go back up to the top of the list for planning for incapacity. That's the big one. That's the one when I had clients that would come in and had as much gray hair as I have now, you know, really that's when we'd start talking about, all right, when you get to later years, we need to start thinking about what happens if you can't handle your own stuff. You know, what happens if incapacity comes along? And that could even happen for younger folks. It could even happen, gosh, we all drive on 285. We could all be in car accidents. We could all have brain injuries. Those are all things that we could all have issues with. And if your assets are in a revocable trust, that revocable trust has a provision in it that says, if I ever become incapacitated, this trust is no longer revocable. It's an irrevocable trust. And this other person or entity or bank or someone steps into your shoes as the trustee and basically can start managing things for your benefit, making sure that all of your bills can be paid and that all of your investments keep going. Those are all things that we think about for revocable trust. So those are the big reasons people use them here in Georgia, is the incapacity planning. And whereas I used to almost never see revocable trust here in Georgia, they've gotten to be much more in vogue. And that might be because of the driving on 285 issue, that we never know what might happen and when we might become incapacitated. It might not have anything to do with your gray hair. It might have something to do with an accident of some sort. So planning for incapacity. So irrevocable trust, that's where a lot of folks say, I don't want to pay any taxes. Well, right now the exemption levels are so crazy high. You know, a married couple has to have, you know, north of $24 million before they have to even worry about estate taxes, but that's set to go down in the next few years. But even if it goes down, it's probably going down indexed for inflation. We can't really say exactly what it's going down to, but let's just plan on about 7 million is what it would go down to per person. So if you have under $7 million, you don't need to worry about the alphabet soup, the spout, all these different acronyms, the spousal lifetime access trust, the qualified personal residence trust, the irrevocable life insurance trust, the alphabet soup of all of those. If you don't have north of $6 or $7 million, even when the exemptions go down, it's not something you're really going to have to worry too much about. But that said, there's all these other things that we've got listed below: asset protection, charitable trust, special needs trust, and also just taking care of your family after you're gone. Remember, we talked about setting things up during your lifetime versus setting them up when you're gone. Most of these things, when we're talking about the special needs trust or asset protection trust or family trust to coordinate the efficient wealth transfer of wealth, those are things that a lot of people set up within their wills to take care of their families after they're gone. So I have two sons. I have a 17-year-old and a 21-year-old, and heck no, I don't want them to get even our meager wealth that we have. I would not want to just hand that to them, because at this stage in their life, it would stunt their growth and stunt their ability to go out and actually create, you know, productive members of society out of themselves, and it would be gone. You know, my youngest son likes fast cars. No, the answer is no on those. And so that's really the reasons for setting up irrevocable trust, or all of the things in this list. And the big one that affects nearly everybody on this call is protecting the assets and coordinating the actual transfer of wealth after they're gone. My son, my 21-year-old told me last night that he wants to propose to his girlfriend. Big thing. Oh my goodness, that's especially moms of boys sitting down talking to me. They're always wanted to protect against those money grubbing potential future ex-spouses. That's another big reason that people set up trusts, is because they want to make sure that if their children were to get divorced down the road, that they wouldn't be able to get a hold of their assets. And the other thing that I hear incredibly sadly about on nearly a daily basis is I get calls from families who say that they've got multiple kids or just one kid, and most of them are doing all right, but they've got one child that's either got mental illness or addiction issues. And that takes some major planning. And this is not a Cumberland Trust commercial at all. I'm not going to make it into that, but we are one of the only trust companies I know that has a special department where the trust officers solely work with beneficiaries with mental illness and addiction issues. So that's something that is incredibly painful for families working through what in the world to do to make sure that their kids are protected against themselves, against other people that want to take advantage of them. That's a reason for an irrevocable trust. So now everybody says, okay, I need one of these. I need a trust. So how do you choose the right trustee? So let's talk about what can happen if you choose the wrong one. So there's kind of two main buckets you can put trustees into: individuals, like naming, Brother Bob, or naming a corporate trustee. So let's talk about first some issues with naming individuals. So there's some small problems that can come up with individuals, such as they just didn't have enough time. I used to hear people say, well, I'm going to name my uncle because my uncle is a president at a bank and he definitely has the right skill set to be able to do this. Well, if he's the president of a bank, he probably doesn't have the time to do that and to stop and think about this, or they don't have the right skills. I sat down with a family a couple weeks ago, big wealth family, big wealth family. And they've got a lot of trusts, a lot of trusts set up. And I was sitting down with certain members of the family that are starting to think, well, maybe they shouldn't have individuals as the trustees, because they've got just the different siblings named as the trustees for different people, and they've got a lot of trust. And so we started talking about the different things, and they kind of all looked at each other and they said, did you send those notices out last year? I didn't send those notices out last year. Oh gosh. And these are smart people. They're just really busy and it wasn't top of mind, and they're not experts. They're absolutely not experts, even though these are incredibly smart people. Just the wrong skill set, and they didn't have the time and weren't paying attention to these trusts that they needed to. That's typically what happens with individuals, but those are the small problems. The big problems when naming an individual is stealing from the trust. All right, so your uncle, who's the manager at a bank, his bank goes under. He's got one of these California banks and it goes under. And well, there's a nice little bucket of money. I could just take a little loan from that real quick and nobody will ever know. I'll pay it back before anybody knows. And he's not a bad guy, but he's got bills and he needs to just dip in there and get that. Well, that's not right. Unethical, illegal, all of those good things. So those are issues that you come up with. And when we're talking about irrevocable trust or beneficiaries that don't have capacity, when you're talking about elder fraud, it's often family members that are dipping in and, you know, she's got dementia, she'll never know, she'll never miss the money, she's got plenty. That at 60% of those, you know, the elder fraud is perpetrated by family members. So just keep that in mind when you're choosing that. So when we start thinking about big banks, so we already talked about individuals, now let's talk about banks. So I'm just jumping right to the big banks because that's where most of the issues happen. So when you move and you name a big bank, so let's just say you name Truist. Truist is in the building that I'm here. Actually, I'm looking right at a Truist right out my window. But yeah, when you name Truist, they move all of your assets from your current financial advisor, and they move all of the assets onto the bank's platform. And the team that you've had in place for years and who you trusted, they're out. And I hear a lot about the investment structures that big banks put folks into. It's really incredibly conservative and very rigid. Those are the two kind of things that I hear people complain about the most. I was talking with somebody, let's say it was an $8 million in trust relationship. And over the last few years, he's made 3%. And that's across everything. And that it was during a time when the market was doing much better than that, and he was livid. That's what his investments were making at the time, and it's because it was a large bank trust department. When I say impersonal distribution standards, so if you go and you open up your wills or your trust that you have, I bet you it has something in there talking about distributions to the beneficiaries for their health, education, maintenance, and support, or some variation of that. Those are the magic words the IRS tells us to use about distributions. Well, it probably doesn't say anything in there about just give them 3% no matter what. That's probably not what it says, but big banks, they don't have time, and that's often what they'll do. It's a very impersonal distribution standard. And when I say they don't have time, I'm talking about overworked trust officers, because most of the trust officers at big banks have 200 to 300 families they're working with. And that was a number, when I found that out, I was shocked. You have to have an impersonal distribution standard. It has to basically be run on a calculator rather than actually getting to know the families to understand what their needs are. And here's the big one that I've been running into a lot lately. Folks drafted their documents, they put in US Trust, or they put in Truist, or they put in some other big bank as their trustee. Person dies, and they go to administer the estate, and they call up the big bank, and the big bank says, oh, you don't have 5 to 10 million? Sorry, you got to find somebody else. So their minimums have gone way up in the last few years. So those are things that can kind of go wrong, but how do you pick the right one? Okay, so here's kind of we're going to walk through a couple slides talking about what are the jobs of a trustee and what are the kind of key abilities they need to have. So, really, one, they've got to be able to read the document and to actually say, all right, I am committed to actually doing what's in this document, such as the big family I was sitting down with a few weeks ago. They had read the document, but they weren't, they had forgotten. They had forgotten that they were supposed to send out these notices and do these things. And if the IRS were to come knocking, it could have caused a big old problem for the way these trusts were treated. So the other thing that I get phone calls about fairly often is I get calls from beneficiaries to say, I'm the beneficiary of a trust and my aunt is named, but my aunt has never liked me. She's always liked my sister more. And so my sister gets whatever the heck she wants. And, I don't get anything. Well, that might be what the original grantor intended, because this beneficiary might be a ne'er-do-well. And, that might be what they intended. But if that's not really the case, and it really is just somebody being more partial to somebody else, or the sister is able to kiss up to the aunt more, then that's not really the way that it was originally intended. And keeping proper books and records. These are all issues. These kind of three things that I'm talking about here, those are issues that I see most often when it's an individual serving. Don't really see that problem with corporate trustees. But here's some qualities to consider, and Jeff can send out. I'll make sure he's got this PowerPoint so he can make this available to anybody who wants it. So you can kind of, when you're sitting down, keep this list in mind. These are kind of the things that you need to make sure that not only can they do, but they are willing to do. And they're willing to actually be fair, diplomatic, and impartial, whether it's actual or perceived that they have some kind of partiality toward one person or one beneficiary or the other. That is a quick way to get your trustee sued. In the estate planning world, the attorneys who make the most money are the ones that are the fiduciary litigators, because that happens all the time. If they're not actually, even if there's a perceived idea that they are being impartial and not making distributions when they should, that's a fast way to get them sued. And again, this is another laundry list. I'm not going to read these all to you, but this is another laundry list of just different things to keep in mind, and different responsibilities of what a trustee needs to do. And everybody says, oh, it's really easy. They just, they'll get the statements from Jeff, make sure it looks okay, and then, pay the kids tuition. No, that's really not all it's all about. There's, a whole laundry list of things that the trustee is responsible for doing over time of the trust. So now talking about, when to consider a corporate trustee. We've talked about, what can go wrong with an individual, but here's some actual specific times that I would recommend having a corporate trustee. So one, there are no individuals that you want to name. The people that you want to name are, your age or older. I hear that all the time. It's like, well, I'll name my mom. Well, my mom's 80. No, I can't name my mom. And if there's any kind of arguments between the beneficiaries of the trust, do not do that to an individual. Again, they are going to get sued. If they will not thank you for being named as a trustee. If there's a blended family, you need somebody who's an outsider to step in, especially if you're setting up a marital trust for the surviving spouse and it's a blended family. I hear people all the time say, oh, no problem, I'll have my son serve. I'm like, your son, who's not the child of your wife, serve as the trustee on her trust? It's a recipe for disaster. It really is. I mean, there are some very certain circumstances where I could see maybe, but actually, no, I can't. I take that back. I can't. We can't anticipate, how things are going to go once the kind of binding person of the family is gone. And if there's any kind of special needs or senior care concerns, especially special needs, and there are disability benefits that we need to keep in mind, those are incredibly complex rules. I'm an attorney in that area. I drafted special needs trust for years, and I am still constantly learning about different, traps for the unwary in special needs trust. So getting very close to the end. Again, we're talking about, well, we've actually already covered most of this. You have different kinds of corporate trustees. You've got the big banks We already talked about that. That's Truist, US Trust, the big guys, the big banks, the big names that you see when you're driving down Peachtree. The other kind of category, then there's three categories, or at least three that I think of with corporate trustees. The next one's kind of the smaller full service trust companies. Those are the folks, they're not the big banks. They don't have 200 to 300 families per trust officer. You're getting much more individualized attention, but they're a full service trust company, which means that they also manage assets. They manage investments and will move all of your investments, away from the relationships that you've been trusting for years and move it onto their own platforms. And then the third option is the opposite of that. It's also the smaller independent trust company, but it's not the full service. They don't manage money. And there's a special, statutory phrase for that, and it's called a directed trustee. In your documents, you would direct the trustee to hire a certain financial advisor, Jeff, because he's sitting here looking right at me on my other screen. But that you would name in your documents who you would want to still stay on the team to manage your assets. Those are the three kind of categories of corporate trustees to think about. So not all of these corporate trustees are created equal. And this is just a slide I kind of created for you all to keep in mind when you're sitting down with your attorneys and you're saying, okay, here's the issues with the bigger banks. Here's all the different things that you want to think about. Does this matter to you? Do these different bullet points matter something to you? And if they do, then going back a slide, it'll make the decision for you on what you want to do. If those things on this slide don't make a difference, you say, okay, I'm okay with that. I just need someplace that's stable and going to really look after my stuff. Okay, fine. Go with the big bank trust department. Oops, I went too far. But if these things really do mean something to you, then you need to think about who you're going to name on that. And everybody, even after the slow start in the beginning, I was able to finish on time. So yay!
Well, thank you, Shelly. This has been awesome. Sorry, you guys, my delay in getting us cranked up tonight. I joked with Shelly before we even started. We sort of did a dry run on turning it on and hitting the right screen and sharing the screen. I said, but don't worry, none of these people expect us to be webinar experts, and we've proven that tonight that we're not experts on running webinars. But I started tonight's presentation, talking a bit about the importance of having a team, a collaborative team to work with. And there obviously, your estate planning attorneys might be on your team, and your tax counsel may be on your team. Obviously, we as your wealth advisors would like to be on your team. But it's really important to collaborate. And many years ago, as we started working with clients that had trust, the default was normally to select a family member or a close family friend to serve as trustee. And as we've all aged, I'm finding that's more difficult, finding the right people to serve as trustees. Not only that, as your children age and some have challenges or special needs or unique circumstances, you do have to think about, does it make sense to have someone other than an individual to shepherd this capital, either for yourself or for the next generation, if the next generation is not prepared. Shelly, thank you for your kind words about retaining and working with your financial advisor. I think what I would just want to point out is that's not really our objective. Our objective is for you to have choice. You know, and your family knows what's right for you. And if we work together and you feel comfortable with our investment philosophy and the way we do client engagements, if you would like your children or your next generation or whoever the beneficiaries are to have access to that, obviously we'd be delighted to be a part of that conversation. But we want you to have choice. And so what some of these directed trustees give you the ability to do is have choice in terms of how you manage the resources. And the directed trustee can do an excellent job in all the administration functions that Shelly's talked about. So Shelly, I do have a couple of questions here. You okay for a couple of questions?
We're good.
Okay, let's see if I can interpret these. I have to get past the ones that are yelling at me because I'm so bad at webinars. So I'm just kidding. So I've got the first one here, and some of these may be so specific you're uncomfortable, but let me just read what I've got here. We have 2 grown siblings, which each get 50% of our assets when we both pass under our will. Would a trust make sense in addition to our wills?
So remember we talked about there doing 2 different kinds of trust. So there's a revocable trust and there's an irrevocable trust. So the revocable trust, the in addition to your wills, that's something you would have a will and you'd also have a revocable trust. And that's something you would set up now. And that was really for incapacity planning as you age or drive on 285. But the question about for your kids after you're gone, that's definitely something I'm not going to punt completely and say talk to your attorney, but I am going to say that there are definitely reasons why you might want to do that. And you say they're adults, and you say that that the assets are being split 50-50. But all adults aren't created equal. Are they ready to actually manage those assets? Do you like their spouses? Do you know their spouses yet? Or it could be a future spouse or an ex-spouse. Those are the things that people want to protect against. So in my own situation, so let's just say my oldest son gets married, and so I know his spouse, and she's very sweet, and I'm fine with her, but I don't know what the future might bring. Potentially setting it up so that the assets get split between my 2 boys, and they get held in trust, and they stay in trust for the boys' lifetimes. And no matter how old my boys are when they die, that I could set things up to say, for the first 10 years, there's going to be a corporate trustee, okay? Because they're not used to managing whatever level of wealth they would be getting from us. And then after the first 5 years, they can become a co-trustee along with the corporate trustee to start kind of getting the lay of the land and learning how to actually manage these assets as they're being doled out for them. And then after that first 10 years to say, okay, now you can be your own trustee. That's definitely appropriate for lots of people. Now you can be your own trustee, but it's still in that trust wrapper that provides a lot of asset protection, such as credit card debt can't get into that trust. If they decide to be real estate developers and their deals go belly up and their personal guarantors on those loans can't get into the trust. All those trust assets are protected from creditors or from future ex-spouses. So there's definitely reasons to talk to your attorney depending on your asset level on whether it makes sense for that extra complexity. If we're talking about, there's $1 million and there's 500,000 that's going to go to each of the boys, that's probably going to get spent. It just probably is, on things and kind of rolled into their own planning. But if you're talking more than about $1 million to each, then yeah, that's something that most folks want to protect a little bit more. So there are reasons.
Yep. Well, and again, no one is ever satisfied by this answer, but it depends.
Right.
So
exactly.
Every circumstance is different. I got another question here for you, Shelly, and it's really related to cost. And I guess there are really 2 costs that we should think about. The first one is obviously setup cost in drafting documents, and then cost to administer. So the question is there a minimum asset level that justifies setting up a trust?
Setting up a trust, as in drafting a trust, no, not really. Incapacity planning, that really touches everybody. And if you've got assets, beyond just, tens of thousands, then yeah, you've got assets that need to be protected if you became incapacitated. That's definitely.
So those are one-time legal fees to draft the documents and get them in place. And then
Right.
what about an asset level where it makes sense to use a professional corporate trustee of some type?
Got it. So most corporate trustees, even the more kind of the smaller independent trust companies, and I'm not saying run a, fly by night. Our trust company's been around for 22 years. I mean, it's not just a brand new trust company. They're not, and it's not small. We're $6.5 billion. So independent trust companies doesn't necessarily mean we're small. But even independent trust companies, I don't really know any that will take a family relationship under $1 million. And depending on if it's a special needs trust, most of them won't take it if it's under 2 million.
Okay. Yeah. So the structure of a trust can still be valuable for everybody, but you would name individuals or family members or a close friend or a non-corporate trustee. But $1 million is kind of the threshold
Right.
where it usually makes economic sense that a trustee could be of value. A
Right.
corporate trustee could be of value. Okay,
Yes.
great. Any other questions here? There's none other that have popped up yet. Let's just give it one more minute here. I think that's it. I apologize once again, gang, for having you hang on the line there as I've figured out the technology. Shelly, thanks so much for being here. Again, it's a pleasure having you and having you and firms like yours available to organizations like ours so that we can collaborate to try to help our clients accomplish their financial goals. All of you know the team. They're here on the screen. If we can help you in any way or answer any questions, please reach out. With Shelly's permission, I'll shoot out the PowerPoint presentation on the webinar, and a replay will also be available in the coming days. So thank you all for joining us tonight. Have a great rest of your evening, and take care.
Bye, everybody. Thanks for having me.